And get things started today. First of all, you guys all should have received minutes for January 12th, 18th, 19th, and 20th. Everybody received those, and if so, does anybody care to make a motion?
Move approval of the minutes.
Representative Smith, Representative Patton, second. All in favor say aye.
Aye.
All opposed? All right, minutes are passed. Now on to bill introductions. We only have a handful of those today. I'm going to kick this off with a request to introduce 22 RS 3001. And this is an act concerning the Department of Corrections relating to inmates in custody and establishing protocols to use the Work Keys Career Readiness Assessment. Are there any objections to that introduction? All right, seeing none. We'll consider that request. Representative Smith, we'll call you, not Representative, Adam Thomas. Sorry, don't know why. I was thinking. Don't mind me. I was talking to Smith, looking at Thomas. I don't know.
It happens all the time.
Just do your thing.
Don't worry about it. I respectfully, committee, request introduction of bill RS number 22 RS 2950, dealing with waiver of extradition prior to release.
Very good. Committee, any questions? Any objections? Seeing none, we'll introduce it or request it to be introduced. Thank you. Let's see, next on the list, Representative Heiberger.
Thank you, Mr. Chair. On behalf of Representative Finney, I'd like to request a bill that would expand the membership of and increase the diversity of the Commission on Peace Officers Safety and Training. The bill draft number is 22 RS 2974.
All right. Any questions, committee? Any objections? All right. Seeing none, we'll request that one to be introduced. I believe we have Scott Schultz joining us. Certainly.
Good afternoon. This is Scott Schultz, Sentencing Commission Executive Director. We'd respectfully request RS 3024 to be introduced. This is a criminal justice bill that is recommended by the Joint Committee on Corrections and Juvenile Justice, the Kansas Criminal Justice Reform Commission, as well as the Sentencing Commission, that deals with expanding the number of presumptive probation and border grid blocks, as well as modifying some certain sentencing terms for certain drug offenders.
All right. Any questions, committee? Any objections? All right, we'll get that requested. Thank you. Representative Hsu, do I see you kind of back there? You got one for us?
Thank you, Mr. Chair. Yeah, just loitering around. Commerce isn't busy enough today.
Surely not.
So I request introduction of 22 RS 2957. I've been working with a law student who presented me as part of her class, and she followed up afterwards and said she wanted to pursue it. So I thought I'd work with her. And it addresses motorcycle profiling, which is fairly fitting with our guest in the Capitol today.
All right. Thank you very much. Any questions, committee? Any objection? All right. We'll request that. Thank you, Representative. Let's see. I believe I have Willie Prescott next from the Attorney General's office.
Thank you, Chairman. Owens and the committee, I'd like to thank you for this opportunity to request the committee introduce the following bill at the request of Attorney General Derek Schmidt. It's 22 RS 2801. The Reduced Armed Violence Act, increasing criminal penalties for certain violations of criminal possession of a weapon by a convicted felon that involves firearms. Thank you for the opportunity.
Certainly. Committee, any questions? Objections? All right, we'll get that requested. Thank you, sir. All right, who owes us candy? Okay, darn. All right, Shelley, welcome. It's good to see you again. Certainly.
Chairman Owens and members of the committee, I'd like to thank you for the opportunity to introduce and request 2 bills. I'm Shelley Williams, Director of Riley County Community Corrections, and I served on the Criminal Justice Reform Commission. The first bill I'd like to request is 22 RS 2619, and this updates the community supervision statutes in Kansas to make conditions of supervision consistent statewide. The second bill I'd like to request is 22 RS 2695, which requires that community supervision agencies coordinate with each other to stop instances where more than one agency is supervising one person at the same time. These bills would provide consistency and supervision across the state and reduce duplication of services and expenditure of resources. Thank you.
Wonderful. Thank you. Committee, any questions on those 2? Any objections? All right, we'll get those requested. Shelley, thank you for being here. I know you've put an enormous amount of work into that committee and the work and those bills, and I really appreciate that. All right, anybody else that I've missed? You know, I think that's going to end up being introduced in judiciary, apparently. As you guys can tell, there's a lot of bills introduced here at the very end. And for perspective, this week might end up being slow, but I can promise you next week won't be, because these things have got to be requested in the House and then added to the House Journal. And so likely it'll be next week before we get to take up a lot of these topics. So it's going to be pretty full, but that's all right. We appreciate everybody getting those introduced. With that in mind, we'll go ahead and move into our bill hearing for today, and that is House Bill 2515. And we'll ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2515 would create a mechanism to seek relief from the Kansas Offender Registration Act requirements for drug offenders, and it would also allow expungement of offenses when that relief is granted. I'm going to start with Section 2 of the bill because that's kind of where the big chunk of substance is being changed. That section amends KSA 224908. That's the statute that currently provides that no person who is required to register as an offender shall be granted an order relieving that offender from the registration requirements. This bill would provide that except for offenders required to register for an out-of-state conviction or adjudication. A drug offender who's required to register under the Kansas Offender Registration Act would be able to file a verified petition for relief from registration requirements if the offender has registered for at least 5 years after the date of parole, discharge, or release, whichever is most recent, or if not confined 5 years from the date of conviction or adjudication. Offenders required to register for an out-of-state conviction or adjudication would be able to file that petition when the offender would no longer be required to register under the laws of the out-of-state or out-of-jurisdiction wherever their sentencing court was. Any period of time during which an offender is incarcerated would, or is not in compliance with the Kansas Offender Registration Act, would not count toward the duration of time needed to file that petition, so it wouldn't count toward that initial 5-year period. A petition for relief shall be filed in the district court in the county where the offender was convicted, or where the offender is required to register in the case of an out-of-state conviction or adjudication. The petition would include the offender's full name, the full name at the time of conviction or adjudication, their sex, race, date of birth, the offense requiring registration, the date of conviction for that offense, the court in which the offender was convicted, whether the offender has been arrested, convicted, or entered into a diversion agreement during the duration of registration, and the names of all treatment providers and agencies that have treated the offender for mental health, substance abuse, and offense-related behavior since that offense. The Judicial Council would be required to develop a petition for use under this section. When a petition is filed, the court shall set a date for hearing and give notice to the county or district attorney. Any person who has relevant information related to the offender can testify at the hearing. The county or district attorney shall notify any victim or the victim's family. The victim's family shall not be compelled to testify, however. The county or district attorney shall have access to all applicable records, including otherwise privileged or confidential records. The court can, at their discretion, require a risk assessment for any offender who is petitioning for relief under this section. That assessment would be performed by a professional agreed to by all the parties, and it would be done at the offender's expense. The court shall order relief from registration if the offender shows by clear and convincing evidence that the offender has not been convicted of a new felony in the immediately preceding 5 years. The offender's circumstances, behavior, and treatment history demonstrate that the offender is sufficiently rehabilitated, and the offender and registration of the offender is no longer necessary to promote public safety. If the court denies a petition, then the offender would not be able to file another petition for 3 years unless a shorter time is ordered by the court. If the court grants the petition, it shall order the offender to be removed from the registry. Within 14 days, the court would have to notify the KBI, which shall remove the offender from the internet website that's required to be maintained under KSA 224909. An offender can combine a petition for relief with this section along with a petition for expungement if the offender would otherwise be eligible for expungement. And that's when we get back to section 1, which amends KSA 216614. That's the expungement statute. Current law there provides that an offender who's required to register would not be able to be granted expungement of any conviction while they're required to be registered. This bill would add an exception to allow offenders who've been granted relief from registration under section 2 to file for expungement for those offenses. And I can take any questions.
Thank you, Natalie. And maybe this is a question for you or for research, but is Kansas the only one that has a drug offender registry? I've heard that somewhere.
Yes, I believe we are the only state that has a drug offender registry.
Would you mind also, there are a few new people in here and kind of off the cuff, share with us that these offender registries are more of a civil process than they are a criminal process? Can you share that maybe a little bit with us?
Sure. So under the Kansas Offender Registration Act, we have different categories of offenders. We have sex offenders, violent offenders, and drug offenders. And essentially, once a person either gets out of incarceration or if they weren't incarcerated is otherwise convicted for an offense that's described in that act, and they are required to register, then they have a civil obligation to register under the Kansas Offender Registration Act. And in order to register, they go to the sheriff's office in the county where they live. If they work in a different county, they have to also go in that county, and then any county where they go to school. And they register with the sheriff's office 4 times a year, which puts them on that registry. And then the website that I mentioned that's maintained by the KBI under KSA 224909, that's the public website. If you guys are familiar, if you've ever been to the offender registry website, you can put in your address and you can see people who've been convicted who are required to register in your neighborhood, or if you want to put in the address of your workplace or school, you can see folks who are required to register.
Very good. Thank you, Natalie. Questions from the committee? Representative Carmichael.
Thank you, Mr. Chairman. Just following up, Ms. Scott, this civil registry, what is the consequence, though, if someone's subject to registration fails to register?
Failure to register is a crime. I believe it's a Class A misdemeanor, and then it bumps to a felony. I'll have to get the exact severity level for that felony. But it does carry criminal repercussions if you fail to comply with your offender registration requirements.
So then, just to follow up, while the requirement might be civil, the penalty for failing to register is criminal?
Yes.
Thank you.
Thank you. Anything else? All right. Thank you, Natalie. All right. We'll now hear from the proponents. Let's see. We have Eileen Berquist with the American Civil Liberties Union. Eileen, welcome.
Committee chair and members of the committee. Ooh. All right, are we good? All right, thank you. Thank you for the opportunity to present today. My name is Eileen Berquist. I am the Community Engagement Manager for the ACLU of Kansas. Natalie spoke very briefly about what goes into being registered on one of these lists. Every time you make a life decision, it's not just every quarter, but every time you make a life decision, like buying a car or deciding to go to a different school or taking a job in another community, if you're going to be away from your home county where you register for more than 3 days, You then have to register in that in that county. So this is, for someone's administrative life, very intensive. And even missing one day can have serious consequences, as Representative Carmichael mentioned. There can be some serious legal consequences to this, up to a felony. And these are just the logistical harms. I think it was also mentioned that all of this is publicly available information. So without any hard research to show that having this information public provides any positive impact to public safety, you can look up any kind of offender in your neighborhood and get really intense information about them, really private information, not just what you might see on someone's Facebook profile, but identifying scars. You can get the license number on their car. You can learn a lot of information about someone just out there in public. So it's a huge imposition of privacy, again, for folks who may not need to be having that information out there for public safety. Also, this was sort of mentioned, but we have one of the most restrictive offender registries in the country. A Kansas service analysis found no other state imposes such demanding rules on such a wide range of people. And these restrictions have ballooned in recent decades. I know there are going to be some other folks speaking to how that has come about and some ways that they can be remedied. So I won't go too deeply into that. I think overall it's important to have an exit ramp for people in Kansas who have served their time, completed all parts of their sentence, and don't pose a threat to their communities. So this committee has the chance to create a sensible way for drug offenders to get off this registry. Additionally, we request that no docket fee or risk assessment fee be charged, as they really limit the ability of people to engage in this kind of process. So in short, we support this bill with the caveat regarding docket fees and other fees associated. And we hope you will take a moment to look at the additional resources that we have added to our testimony.
Thank you, Eileen. Committee questions? Representative French.
Thank you, Mr. Chairman. This may be a question for Natalie, or it could be for you. I don't know. What's the level of drug offender that gets on this list?
Yeah, we'll let Natalie take that one.
Thank you, Mr. Chairman. Let me pull it up here really quick so I can tell you exactly. Okay, So for folks who have to register for 15 years, that's what the drug offender registry requires. We have unlawful manufacture or attempting to unlawfully manufacture any controlled substance, and then possession of what we typically refer to as precursors. So it would be manufacture, distribution, and possession of precursors. That's the group of folks that we're talking about, and they're currently required to register for 15 years.
And so this is the group we're talking about reducing their time on this registry?
Mr. Chairman, the bill as drafted would not reduce the amount of time that they're required to register, but it would allow them, after they have successfully registered for 5 years, they could file a petition for relief from the registration requirements. And then the court would be able to conduct a hearing to determine whether that relief should be granted.
Thank you, Natalie. Thank you, Mr. Chairman.
Thank you. Other questions? Seeing none. Thank you, Eileen.
Thank you.
We'll now be pleased to hear from Jennifer Roth, Legislative Co-Chair, Kansas Association of Criminal Defense Lawyers. Jennifer, welcome.
My name is Jennifer Roth. I am here today on behalf of the Kansas Association of Criminal Defense Lawyers. I am a criminal defense lawyer. I have worked as a public defender for the better part of 23 years, and so that's where I have a lot of my information from. I've represented people in district and appellate courts who have been charged with registration offenses. I've actually been testifying about the Kansas Offender Registration Act in front of legislative committees since 2006. So there's a lot of things I don't know a lot about, but one thing I do know a lot about is KORA. So I would encourage and if anybody has any questions about how it works, who's included, how we got to where we are today, I'm certainly available to answer those questions now or at a later time. So I have submitted my written testimony, and I wanted to make a few points that were not included on this, or not elaborated on. But I guess maybe first I wanted to answer a question about that you all were talking about a minute ago. So the offender registry covers anybody convicted of distribution or possession with intent to distribute, and that's any amount. It doesn't matter how small or large. If it's a distribution offense or possession with intent to distribute, it's a person that has to register, and that includes people who sell to undercover informants, give stuff to their friends, your standard drug deal in the alley, all those kind of folks. So it's not just people who are convicted of manufacturing or possession of precursors. And in fact, a different version of this bill a few years ago, I remember Sheriff Easter from Sedgwick County telling us that there's not actually that many manufacturing cases anymore, but there's still a lot of distribution cases. So I would just say that I'm not sure what the number is now, but this time last year there was 5,700 drug offenders, drug registrants on our registry, and I would wager that the bulk of those are people convicted of distribution of varying amounts, and probably pretty low-level amounts too. So anyway, the other thing I wanted to say about Representative Carmichael's question is about the penalty when you fail to register, when you fail to comply in any way. It's always a felony. And at a minimum, it's a mid-level felony. So if you don't report a new tattoo, your jet ski, your new work address that you moved, if you don't do those things within 3 business days, it's severity level 6, which is akin to arson, attempted aggravated battery, great bodily harm. So it's a very serious offense, and that's just the lowest level. It actually goes up from there. So I just wanted to clarify that it's never a misdemeanor to fail to comply unless you don't pay your $20. So at any rate, sorry, I kind of got off track there. But just so everybody knows, I see that you have testimony from Danny. I don't know if Danny's here, but he's one of your proponents. And I'm glad you have that, because it's people like him that can speak best as to why we need to have this exit mechanism. This is a man who had a judge and a prosecutor saying that if the law was different, I'd let you off this second, but it's not. And not only could he not be removed early from the drug registry, he can't move to expunge his underlying conviction, because the law currently says that as long as you have to register, you can't move to expunge any conviction you have, not just your drug one. So I feel like I could talk to you about lots of my former clients who I believe are also deserving of this, but you have in the very words of a man who would fit under this perfectly, and so that speaks volumes. I also feel like not having an early removal is sort of inconsistent with other things that this legislature believes, which is that if you better your life and if you do what we are asking, then we'll give you hope that you can have a better life and not be burdened by this registry. So I feel like having an exit mechanism is consistent with that. Another thing I want to let you know is that obviously if people are successful under this exit mechanism, they would be removed from the registry. And I just wanted to remind folks that in 2013, this legislature actually changed an effective date in the drug offender registry that resulted in hundreds of people being taken off the registry because it gave a new start date, so it said people that were convicted on or after July 1 of 2007. And I can't put my finger on how many people that was, but it would have been 6 years plus before 2007 worth of people, which I would wager is at least hundreds. And I tell you this because I've never heard anybody say since then, in 9 years, that the sky fell when all those folks were taken off the registry. And I think that's because the sky didn't fall. And so I feel like what I'm saying here is we have an example of what happens when you have a lot of people removed from the registry and the sky doesn't fall. And in this case, it's going to be people that have to meet a certain process. I guess I'm going to tell you one other thing, that I understand that there are proponents here who would probably support this going further. I understand there's a proponent who would not want this measure to go forward, but I would just remind this committee that you have heard from the Judicial Council, you've heard from two law enforcement organizations last year said that they supported this exit mechanism. The Kansas Sentencing Commission has actually been asking for changes to the drug registration even longer. My point here is you have a broad range of people, of organizations made up of a lot of different stakeholders who are asking that we do something differently. And so I think that that is further indication that it is time to undo the broad sweeping things that have been done in the past and actually restore an exit mechanism to our offender registration. I think at that point, I'm not going to talk anymore, but I'm happy to answer any questions. And again, if you think of anything later, my email is on this testimony, and I'm happy to answer any questions.
Thank you, Jennifer. Representative Carmichael.
Thank you, Mr. Chairman. Ms. Roth, does this apply to distribution of amounts of marijuana that the mere possession of which would be a misdemeanor?
No, the drug offender registry has never included marijuana.
That's what I was thinking, but I wanted to make sure we were clear on that.
Yes.
Because I would not want to get caught sharing a marijuana cigarette with the lady down the street who's on chemo if I had to get on the register, so I wouldn't want to do that. My second question, though, is let's assume I work with somebody who has been apprehended going 90 miles an hour the wrong way on an interstate highway. They've just pled guilty to drunk driving and reckless driving. If they were on this drug registry, their tag number would be there and everything, so that my neighbors, we could all be careful when that particular Yukon or whatever it was drives by, because we know it's a recently convicted reckless drunk driver 90 miles an hour the wrong way. Does that driver have to register on some sort of a registry so that me and my neighbors can be on the lookout for recently convicted drunk, reckless, 90 mile an hour wrong way donut boy drivers? No. And I'm never going to advocate for more people to get on the registry. I'm just telling you that. Because I'm aware, but to answer your actual question, no. There is a lot of conduct that we would all agree is harmful that does not require registration. But that is not me saying I want there to be more, because I certainly do not, because I know that there is not the research to back it up. But anyway, I don't see you anymore, but I'm just telling you the answer is no, that person wouldn't have to register, Representative Carmichael. Yeah, I was just merely asking for purposes of proportionality, if you will.
Well, and this is a good point, yes.
Committee, additional questions? All right, seeing none.
Thank you.
I would also submit for your information written proponent testimony from Ed Klump on behalf of the Sheriffs, Chiefs of Police, and Peace Officers Association, Patrick Armstrong from the Council of State Governments, as well as the mentioned Danny Kravitz, a private citizen. Are there any other proponents here? Any neutral conferees? All right, seeing none, we'll move into opponent testimony. Greg Smith, Special Deputy for Government Affairs. Welcome, Greg.
Thank you, Mr. Chairman. I am with the Johnson County Sheriff's Office. I serve as the Special Deputy for Government Affairs. And in discussing this with the administration at the Sheriff's Office, we are in opposition to this for a couple of reasons. Most of them are in my written testimony, so I'll just highlight a couple things and then I'll stand for questions. Approximately 77% of all drug offenders reoffend. That's the whole gamut of drug offenders, but it's 77% reoffend. So we believe that the drug registry or the offender registry allows us a way of oversight for those people that commit those types of offenses. There's been a strong movement towards rehabilitation of those, particularly those that use drugs, and we are not disputing that that is a valid approach. However, it's only as effective as the person that's in the program. If they don't want to succeed, they're not going to succeed. You can't force somebody to rehab. We have seen tremendous success in our veterans program that we have, our Veterans Treatment Court. Also find, I'm the liaison to that court, I also find that the veterans that are in that program are highly motivated to try to change their lives, and that the program is very successful. As has been noted, the offender registry is a civil procedure. It's not a criminal one, although there are criminal penalties if you fail to complete the registry or do what you need to do. However, our own Kansas Supreme Court last September issued an opinion that said that the registry is not meant as punishment. Lastly, we would ask that if the committee does decide to go forward with this bill, that you would remove the possibility that someone who reoffends can get off of this registry. Don't let them get the expungement. Don't let them off of the registry, because we feel that it's most important that they stay on there, particularly if they're showing a pattern of conduct that isn't acceptable. And I'll stand for questions.
Thank you, Greg. Quick question. In your testimony, you mentioned 77% of drug offenders reoffend. During what time period? Is that in the first year, 3 years, 5 years?
I'd have to go back and check, Mr. Chairman, but I believe it was 3 years.
Okay. So under this bill, they, can't even apply until 5 years after, and if they did reoffend, that would be part of the record, and then the judge would then be able to say no because you reoffended, because it is an exit mechanism, not a guaranteed after 5 years. Right. So just wanted to be clear on that. Representative Heiberger.
And this is kind of a follow-up, and thank you for being here today. The 77% figure you cited, is that for drug offenders as a class, or just for the type of drug offenders that are required to be on the registry in Kansas?
That's all drug offenses.
Other questions? All right, thank you very much.
Thank you, Mr. Chairman.
Natalie, I do have one quick follow-up. The 15-year, is that tacked on to the end after sentence is completed? So they've completed their sentence, they're off probation, they're out of prison, they're totally off paper, and then we're tacking on 15 years. Is that correct?
That is correct, Mr. Chairman. So if someone were to be required to be incarcerated, the time would be after their release from custody, or it would start at conviction if they're not incarcerated.
Okay, so it would start at conviction. So they could be on probation for 2 years.
Oh, well, actually, let me double check that if they're on probation. Although Jen knows that off the top of her head.
She's right. It starts, the only time that doesn't count is time that you're spent incarcerated. Okay. Otherwise, it would start on your date of conviction.
Okay. So Jennifer Roth clarified that it would start on the date of conviction if you're incarcerated, or after you're released from incarceration, it would start. So, all right, thank you for clarifying that. Any other questions? All right, thank you, committee. We'll go ahead and close the hearing on House Bill 2515. Thank everybody who was part of that. We'll now move into final action on House Bill 2215 and ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2215 was the bill that would allow drug offenders to be eligible for SNAP assistance, which is food assistance.
Very good. Thank you. Committee, on this bill, does anybody have any amendments? Okay, not seeing any. Anybody wish to make a motion or move this bill? Representative Heiberger.
Mr. Chair, I move that the committee recommend HB 2215 favorably for passage.
Okay, I have a second?
Second.
All right, second by Representative Keither. Thank you very much. Discussion committee. Representative Heiberger.
Thank you, Mr. Chair. I think the testimony showed that we're real outliers on this. And if we really believe in redemption and we really want people to have a chance to get their lives back on track, I think this is one way we can help them do that, and I strongly support it.
Thank you. Representative Smith.
Thank you, Mr. Chair. I just want to reiterate, I think, what I alluded to during the hearing, and that is, I think the mechanism is outdated. It was meant to serve a purpose that it no longer serves, and in that, I think it's time that we go ahead and move this out, and I will be supporting it.
Very good. Thank you. Additional comments, questions? All right, seeing none, Representative Heiberger, you may close.
I close and move my motion.
Thank you very much. Committee, all in favor say aye.
Aye.
All opposed? All right. Anybody wish to have, ayes have it, by the way, my apologies, ayes have it. Anybody wish to have their vote recorded?
Yes, Mr. Chairman, I'm in the State House today.
I saw that. Wonderful. Representative Heiberger, Representative Carmichael, any others? All right. All right, we move that forward. Thank you guys very much. With that in mind, I don't have anything else. Anything else to be brought before the committee today? All right. Seeing none, we will